Hello everyone, welcome to the session on women and criminal law. The objectives of this lesson are, firstly, to understand the crimes against women and to examine the key women-centric provisions of the Indian Penal Code 1860. Secondly, to explore the developments in offences against women in the areas of sexual offences, offences related to marriage and offences related to women's procreation. Thirdly, to have a peek at the procedural laws with women-centric objectives. And lastly, to examine the effectiveness and impact of existing legal structure to redress the situation and highlight the need to strengthen the women's safety laws. Let's start by understanding the position of women under the Indian criminal law. Various social, political and economic changes in the country relegated the Indian women to the corridors of the homes. Many evil customs and traditions stepped in to enslave women either incidentally or intentionally. Women always have been victims of various crimes such as rape, murder, kidnap, cheating, sexual assault, etc. She is physically not safe whether she is at home or on the streets or at work or under the custody of someone. Women, being defensive and non-aggressive by nature and due to her vulnerable physical condition, deserve to have protection of law. Various laws of the country like constitutional law, employment law, family law, social laws, criminal law and procedural laws had to be made or amended to suit the protection requirements of women. In this lesson, we shall focus on criminal law provisions that are specifically designed for women's safety. Although women may be victims of any of the general crimes such as murder, robbery and cheating, just as any male, there are certain crimes that are specifically directed against women like rape, sexual offences, dowry death and cruelty. While few of these crimes are dealt by the Indian Penal Code 1860 alone, a few of them are dealt by special laws as well. Although the provisions are plenty, we will limit our discussion to the few major areas of law like sexual offences, marriage related offences and offences related to women's procreation. Incidental references are made to the Code of Criminal Procedure 1973, the Indian Evidence Act 1872 and other special laws. Sexual offences. We shall first analyze the sexual offences committed on women. Under this heading, we will discuss the provisions relating to obscenity, sexual assault, flesh trade, kidnapping and abduction and custodial intercourse. Sexual offences related to married women would be discussed later in this session. The sections of IPC that deal with obscenity are 292 to 294. Women have been victims of indecent, vulgar and obscene depictions. The test of obscenity is still not settled under Indian law and has been changing with times. They deal with sale, hire, distribution, public exhibition, import, export or advertisement, etc. of any matter which is obscene in general under section 292 and to young persons in particular under section 293 of IPC. Whoever annoys others by any obscene act or songs or words, etc. in a public place is punishable under section 294 of IPC. Unlike the earlier two sections, this section prescribes a nominal punishment. Modesty is the attribute of female sex and she possesses it from her very birth. Outraging or insulting a woman's modesty is an offence under IPC. Assaulting women with criminal force with an intention to outrage her modesty is punishable under section 354 IPC. The offence of sexual harassment of women is housed for the first time in IPC under section 354A. The same offence, when committed at a workplace, is adequately dealt under the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. Use of criminal force to disrobe a woman is punishable under section 354B of IPC, which adds to and supplements section 354. Sections 354C and 354D prescribe punishment for the offences of voyeurism and stalking respectively. The inclusion of voyeurism as a crime under the IPC has made sale of pornography, invasion of privacy and all forms of sale of defamatory pictures as prohibited, and this has resulted in apprehension in the minds of criminals. Voyeurism is also a punishable offence under the Information Technology Act 2000. Section 509 of IPC deals with words, gestures or acts intended to insult the modesty of a woman and makes the perpetrator punishable with simple imprisonment for a term which may extend to 1 year or with fine or with both. IPC comprehensively deals with kidnapping and abduction related offences. Sections 372 and 373 of the IPC declare the offences of selling or buying minors, either male or female, for the purpose of prostitution or for illicit intercourse or for any unlawful and immoral purposes. Kidnapping or abducting a woman to compel her marriage or for illicit intercourse or forcing a minor girl or importing a girl from foreign country for immoral purposes are also punishable. These sections apply only when such actions are directed against women. Let us now throw some light on the most grossly inhuman act which violates a woman's body and strips away her dignity and self-respect, that is rape. Section 375 of IPC defines the offence of rape, while Section 376 prescribes a punishment for rape. Rape law has undergone extensive amendment in the year 1983. These amendments were a result of countrywide criticism by all sections of society against the Supreme Court judgment in Tukaram versus State of Maharashtra, which is popularly known as Mathura rape case. To nullify the effect of this judgment and other cases of that period and to make the law more realistic, extensive amendments were made to the criminal laws in 1983. Sections 376A to D were introduced into IPC. Besides substantive law, procedural provisions under the law of evidence and CRPC were also added and amended to strengthen the law. After the horrific incident of gang rape at Delhi on 16 December 2012, Justice Verma's committee was set up to make recommendations on amending the various laws to provide for speedy justice and enhanced punishment for offenders in cases of sexual assault of extreme nature. Considering the report, the Criminal Law Amendment Act 2013 was passed. Sections 375, 376 and 376A to D are substituted by new sections 375, 376 and 376A to E. New offences have been created and stiffer punishment has been suggested to those committing it, such as leaving the victim in a vegetative state, intercourse by a man with his wife during separation, custodial rape, gang rape and repeat offenders. The IPC differentiates between rape within marriage and outside marriage. A husband would be guilty of rape even if he forces himself sexually upon his wife without her consent. Rape on a woman knowing her to be pregnant and gang rape has been made punishable and treated on par with custodial rape. As per IPC, rape is a sexual intercourse by a man without the consent or against the will of the woman. In case of rape, the general principles are that if a man has sexual intercourse with a woman below the age of 18 years with or without her consent, he is guilty of rape. But if the woman is his wife and above 15 years of age, the act is not a rape. Non-consented physical intercourse with his wife living separately from him under a decree of separation is also punishable. A woman may successfully prosecute a man for rape who had sexual intercourse with her consent when the man knew that he was not her husband and that she had consented believing him to be her lawfully wedded husband. Then such consent under misconception is no consent at all. A similar mistake about the identity of the accused made by an unmarried, widowed or divorced woman provide her with no protection. The newly inserted section 114A of Evidence Act raises a presumption as to absence of consent in cases of custodial rape, gang rape and rape on pregnant women, thereby making the consent of the woman for sexual intercourse invalid. Evidence of character or previous sexual experience of the victim is not relevant in sexual assault or rape cases. Also, Section 228A was inserted into IPC to punish for causing disclosure of identity of victims of certain offences, etc., with a view to protect the rape victims from public attention. Woman is also protected under Section 377 IPC against unnatural offences. The Amendment Act of 2013 inserted a new offence of throwing or attempting to throw acid with an intent to cause grievous hurt to the woman who refuses to marry or sexual advances with imprisonment extending from 10 years to life. Most of the sexual offences are cognizable. Section 309 of CRPC was also amended requiring the inquiry or trial of offences related to sexual assault or rape to be completed within a period of 2 months from the date of filing of the charge sheet. Apart from laws, the major rape and assault cases such as Shopian rape case, Aruna Shaunbag case, Nirbhaya rape case, Priya Patel case, the Mathura rape case, etc., also have had an effect on the functioning of rape laws and their interpretations as well as reformations. Offences related to marriage. Most often, women are victims of matrimonial cruelty. IPC provides many matrimonial protections under sections 493 to 498 and 498A of IPC. Some of them are applicable to both spouses, but seems more to protect the women in particular. She is a victim of mock marriages, bigamy, aggravated form of bigamy, adultery, criminal elopement, etc. Most of these offences are committed only by men. Section 493 IPC punishes a man who makes cohabitation by deceitfully making the woman believe that the accused was lawfully married to her and makes her live with him as wife and husband. But if she was under a misconception as to his identity, even though he did not create that misconception, the man is liable for rape but with lesser punishment. Sometimes parties are made to believe that their marriage is complete, which in fact does not constitute a valid marriage. Legal provision regarding such fraudulent or mock marriages is laid down under section 496 IPC. If the complaint is filed by the first wife, the offence falls under sections 494 and 495, that is bigamy. The first wife is not entitled to complaint under the section 496. Only the deceived girl or her parents shall have to file the complaint under Section 496. Section 494 IPC punishes any person who enters into a bigamous marriage with imprisonment which may extend to 7 years and fine. This section makes bigamy an offence in case of all persons irrespective of religion of either sex except Muslim males. An aggravated form of bigamy is punishable under Section 495, wherein the second marriage is solemnized by concealing the fact of former marriage. Section 497 provides punishment for adultery. The scope of the offence under the section is limited to adultery committed with a married woman, and the male offender alone has been made liable to be punished with imprisonment up to 5 years or fine or both. The consent or the willingness of the woman is no excuse to the crime of adultery. It is noticeable that the wife is not punishable for being an adulteress or even as an abettor of the offence. It is also noticeable that this section confers upon the husband the right to prosecute the adulterer, but it does not confer any right upon the wife to prosecute the woman with whom her husband has committed adultery. It also does not confer any right on the wife to prosecute the husband who has committed adultery with another woman. It does not apply in cases where the husband has an affair with an unmarried woman, either divorced or widowed. In such cases, no one can initiate any action against anyone. Further, Section 198 of CRPC explicitly denies the husband the right to charge his wife with adultery and also denies a woman the right to charge her husband with adultery. Unlike Section 497, Section 498, which deals with the offence of criminal elopement, intends to protect the rights of the husband and not that of the wife. It provides a remedy to the husband who is deprived of the custody and control over his wife. Further, to empower women, Section 498A IPC was specifically inserted in 1983 to protect married women from cruelty and harassment by the husband or his relatives. Until then, harassed wives had to take shelter under general provisions of IPC dealing with assault, hurt, grievous hurt or homicide. To make the offence deterrent, Section 498A prescribes a sentence of 3 years and also a fine for the husband or his relatives who subject her to cruelty. The main focus is on the elements of cruelty faced by the wife. It is to be proved that a woman was driven to commit suicide on account of ill treatment or has been ill treated on account of unlawful demands of dowry. This section does not protect unmarried, widowed or separated women from cruelty by the members of her natal family. Section 198A of CRPC requires that courts can take cognizance of this offence only on a police report or complaint by the woman or her closest relatives or with the leave of the court. Simultaneously, Section 113A of the Evidence Act was added in the year 1983. Under this section, when it is found that a woman has been subjected to cruelty as defined in Section 498A IPC by her husband or relatives of her husband, and she is shown to have committed suicide within a period of 7 years from the date of her marriage, then the court may presume that such suicide had been abetted by her husband or his relatives. Dowry system, another evil faced by women, is developed, nourished and pampered by the Indian society in a way that it has become an evil to the society and a bane to women's life. The legal system containing the Dowry Prohibition Act 1961, IPC, CRPC and the Evidence Act could not contain the epidemic evil. Therefore, to strengthen the anti-dowry law, the criminal laws were comprehensively amended to insert Section 304B into the IPC in 1986. The Protection of Women from Domestic Violence Act 2005 was also passed as an additional protection from dowry harassment. IPC made dowry death a specific offence punishable with a minimum sentence of imprisonment for 7 years and a maximum imprisonment for life. It provided that if the death of a woman is caused by burns or bodily injury or occurs otherwise than under normal circumstances within 7 years of her marriage, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or his relative regarding the demand for dowry, then the husband or the relative shall be deemed to have caused her death. Further, the Indian Evidence Act 1872 creates a presumption of dowry death in case the woman dies within 7 years of her marriage by Section 113B. Sections 304B of IPC and Section 113B of Evidence Act together enabled courts to convict many who escaped the Dowry Prohibition Act 1961 and thereby attempting to reduce dowry deaths. Similarly, Section 174 of CRPC was amended, making inquests by executive magistrates mandatory in cases of suicides or suspicious death of a woman during the first 7 years of her marriage. These three-pronged changes in the IPC, CRPC and Evidence Act are no doubt an improvement over the earlier laws and are important to some extent to safeguard the lives of married women. Additionally, in such cases of dowry death, the judiciary also includes a murder charge under Section 302 IPC, as this allows the courts to impose death penalty on the perpetrators of the offence. Section 406 IPC pertaining to offences for criminal breach of trust applies in cases of recovery of dowry, as it is supposed to be for the benefit of the woman and her heirs. It is noticeable that the offences under Section 304B and 498A are cognizable, non-bailable, non-compoundable and triable by Sessions Court. Offences related to women's procreation. Nature has ordained a primary role to women in procreation of children, and law of the land has bestowed her with certain reproductive rights. But it's the individuals who are taking away these divine rights from women. As an adult, woman is wanted by the family, but as daughters, they are less wanted, less taken care of, less fed, less educated and so on. Thanks to the technology, the girl child is killed before she is born. While they want a woman to come into their family for procreation, they do not want a female child to be born to them. IPC protects the women's reproductive rights as well. Therefore, sections 312 to 314 make induced abortion punishable. Causing miscarriage with or without the consent of the woman is a punishable offence. Causing death of the woman while causing miscarriage is a further aggravated form of the offence under section 314. Preventing the live birth of the child or causing the death of the child after birth are equally punishable offences. Greater punishment is laid down if the offence is committed without the woman's consent. To soften the rigors of the law of abortion contained in the IPC, the Medical Termination of Pregnancy Act 1971 was passed. Thus, we see that the Amendment Act 2013 has brought about the much desired and awaited changes in the law to combat the crimes against women. Public servants are also required to address the complaints on a time-bound process to enable speedy justice to the victims. We shall now conclude this session with a few words. After a detailed discussion so far, we may be faced with a few significant questions. Are these laws really helping curb the menace of the dowry and cruelty against women? Are these laws really deterring the offenders who continue to treat women adversely? People who oppress women continue to do it. Is it due to inadequacy of law or due to flaws in implementation of the spirit of the law? The inadequacy of law is being addressed by amendments to the law. However, such amendments have been piecemeal and not aimed at structural changes. The criminal law needs to be gender sensitized in its conception, formulation and administration to actually ensure equal protection to women. To correct the implementation practices, a few procedural changes have been made with no desired result in this sight. Any number of legislative attempts will be inadequate unless the social attitude of women and towards women is transformed. The best way to end crimes against women and girls is to prevent it from happening in the first place by addressing its root and structural causes. It is high time to include a certain new crimes like marital rape under the IPC in consonance with the passing of time. A systematic and comprehensive approach by the Centre and states in providing speedy justice to the victims would deter further recurrence of the offences. Hope the session was helpful to you. Have a great day ahead. See you in the next session. Thank you.